Thank you. Thank you for trying your hand at running the meeting, the tech for the meeting. And thank you, Kirsten, for helping.
Most welcome. Thomas Weiss is with us here. I think he's off camera. Maybe we can.
Yes.
Hello, everybody.
Hi, Thomas. So it is 1 p.m. on August 18th, 2025. This is a meeting of the Land Use Review Board. I am the chair, Janet Hurley, and I will ask board members to introduce themselves as I see them on my screen. Sarah?
Sarah Hyde, board member, present.
Alex?
Alex Weinhagen, board member.
Kirsten?
Kirsten Sultan, board member, present.
And Brooke?
Brooke Dingeldine, board member, present.
Thank you, everybody. Any updates to today's agenda from board members? It appears that we do not have any updates to the agenda. So for now, how about any comments from the public on any non-agenda items? That would be Thomas at this juncture. Thomas, you have anything for us?
No, thank you.
Okay, thank you. We can come back to that if we get more public attendance further along in the meeting. Consent agenda, we need to review and potentially approve the July 28th, July 31st, and the August 4th minutes. Oh, I'm sorry, Sarah, your hand's up.
I was just going to make a motion to approve all three.
Oh, thank you.
Second.
Thank you, Alex. Any discussion on those three sets of minutes? I'll just note that this is very trivial, but occasionally what seems to happen is the AI will make a paragraph and then it won't put a period at the end of it, which I found a little funny. So maybe just something to look for in the future minutes, not something that we need to correct. So anybody else have any comments on the minutes? Okay, hearing none, all those in favor of this motion, please say aye. Aye?
Aye.
Aye.
Hi.
I saw 5 hands, but I only heard 5 ayes.
I think
I heard the
over
last
Alex.
aye. Okay, that's all 5 of us. So those minutes are approved. Thank you. Next item on the agenda. Wow, we're motoring ahead here. Operations budget and legislative updates. We're sort of low on staff today, but I don't think we're going to have legislative updates. We do want to talk about as a board under operations here, the memo that all staff across state government received from the Secretary of the Administration about return to office. And it appears that the administration has begun to talk about getting more people back to the office more often. The details of that are just beginning to be discussed, I guess, at the upper levels of the governor's cabinet. And I know that there are concerns about this across state government and within our program. We, as a board, haven't discussed this yet. We will keep apprised of the situation, and if there is opportunity for input, the board would certainly discuss that with staff and provide input to the governor and his cabinet, should we be asked. But I think we would definitely want to talk with our staff, perhaps at an all-staff meeting first, and And, you know, I think that in general, things are working pretty well with our hybrid sort of setup here as a program. So, do other board members have thoughts that you would like to share at this time about this issue? Alex?
So the press release or the announcement from the secretary seemed to indicate that the governor's office was going to, you know, have some involvement from various agencies of different types and that sort of thing. So I'm assuming that no one's reached out to our agency yet.
That is correct.
I wonder if it makes sense for us to proactively request that that someone from our group be involved in those conversations.
I think it's a little too early. That's my opinion. I think what happened is the governor had a press conference and said something, and WCAX took it as sort of, you know, a return to office for all state employees when in fact he did not say that. And so the next day, the Secretary of Administration sent out this memo clarifying that this, you know, that, you know, more return to office is being discussed and it's in the very earliest stages. So I don't feel like an organization or an arm of state government as small as ours should insert itself at this point. I think we should wait until there's more information and perhaps an invitation for input. Anything else on this topic?
Well, I
Oh,
guess.
Kirsten.
Oh, sorry. Go ahead, Brooke.
Okay.
Well, I was just going to say, I think that maybe we could make an inquiry to find out if there's more information available at this time.
I don't think there is, and I feel like we should wait. I don't think that the intention of the administration was to reach out and hear from people, and I feel like I don't think it's appropriate yet for us to reach out. I would wait until the next step, till we get a little bit more of an indication of where the administration is on this planning and how we can participate.
Yeah, I guess from my perspective, because this could have significant impact, particularly for, you know, who knows which individuals in the program in terms of their work circumstances. I think we should just pay close attention to the topic.
Yeah.
I guess that would be.
Absolutely. I absolutely agree with that, Kirsten.
Yeah.
Brooke, did you have something you wanted to add?
Yeah, I was going to agree. I think that it is premature, but we should have a close watch on it, because if there's an opportunity for input, we want to make sure that we are able to gather that feedback from our folks and then be able to formulate a position in time.
Yep. And Sarah?
I would agree. I would like to keep our staff well informed as we move through the process. I think using our communication guidance to convey what we find out when we find out, and just be clear and transparent and open about whatever information there is to have, as well as listen and accommodate as we can. I think the other thing too, coming into the organization, is just to recognize the transitions that have occurred and are occurring right now in terms of our file digitization and some of the leaps and bounds that are being made there, and the sufficiency of our space. So future things to have conversations around as we sort of start going down this road. Just, I think there's some other things to add into the conversation to make it a little bit more rich.
Okay, thank you, Sarah. Anything else on this topic at this point? Okay, thank you. I'll just ask, somebody's joined us by phone and has not disabled their mic, and we're getting a little bit of feedback, audio feedback from that. So if the phone participant can mute themselves, I don't know if they can do that or if we have to do that.
I
Do you
think
know
you have
about?
to do it if it's me.
Oh, okay. I'll do that, and then if you need to speak, you need to let us know with the shoot, I don't have the instruction. Yeah, yep. So thank you very much, and I will disable your mic for now. Or
Yeah,
mute
to
you.
clarify, it's *5 if you're a phone user to raise your hand to be recognized. It's *6 to mute and unmute yourself if you're a phone user.
Okay, thanks, Alex. *5 to raise your hand. *6 to mute and unmute, correct? Okay.
Correct.
Okay, so, and because we have another participant, I would like to go back to opportunity for public comments on non-agenda items. And it appears we don't have any at present, so let's move on to budget. Do we have anything to update for the budget, Rachel? Our budget work?
I have no updates this week.
Okay, thank you. So let us then move on to item F, studies and reports. And let's start with the Regional Planning Commission application guidelines, application form, and comment form, which have all now gone live onto our website. And I will be purveying that out more broadly to regional planning commissions and others who are interested in this process. But if you were to go to, actually, I think I'll share screen and just show the state of that portion of the website. So let me get the, okay, so Land Use Review Board. Oh. Okay, share screen. So if you were to go to the Land Use Review Board website, and can you see my screen now? Yes, I can see it. I can see it behind Kirsten. So, and then if you click on a new Land Use Review Framework Act 181, and a pull-down menu comes, you can go to the Regional Plan Approval Process. And you will see that there are application forms and guidance available to look at. If you click on this application form, you will get a link to the PDF. And if you click on that, I'm sorry, it's not a PDF. For the forms, they're going to actually be Word documents. And so here's a sneak preview of what the application looks like. This application will be used for the pre-application stage, for the application stage, for a map amendment application, and for any separate Tier 1B requests. So all types of Regional Planning Commission applications will use this one application form. So that is that. And let's go back. Here are the guidelines that we approved as a board a few meetings ago. They are now in their final format with, these are these are our first set of guidelines, so they are guidelines 1. And the section numbering follows that. So the first section is 1.0, the second section 1.1, and so forth, all the way to, I think, 1.6. And then we are hoping that our second set of guidelines will be the Tier 1A guidelines. So they will be 2.0, et cetera. And this is the guidelines formatting that we have settled on at this point. So, and then finally, here is the pre-application comment form. And this form we will be sharing with all of the state agencies that we hope have interest in commenting on the regional plans, and other organizations, and perhaps even interested members of the public who would like to use this form for comments. They may also do so. So this comment form mirrors the checklist that the regional planning commissions will provide. So I won't go through every section of it, but it basically offers expandable comment boxes for different aspects of regional plans that are required by statute. And so those are all now available on the website, and we still anticipate our first application to come in late September with the Rutland Regional Planning Commission plan. And I think they're excited to be our test case. So I'm going to stop sharing and ask if anyone has any questions about any of that. Kirsten.
Yeah, so just in broad terms, and I think we've gone over this some before, but maybe if you could explain, the forms are mirror the guidance, basically, is my understanding.
The comment
there's
form
nothing-
was.
Well, the comment form, but also the application form, like it just flows out of the guidance. I mean, it's not incorporating other requirements.
The application
consistent
form,
with the guidance, right?
yeah, it's consistent with the guidance, yeah. I wouldn't say that application form mirrors the guidance, but the comment form definitely does.
And we've published it and put it out there for users because people need this now, and so that they can start preparing their submittals that we anticipate arriving next month. Yeah. Okay. I hadn't looked at the application forms yet, but I'll let you know if I have any questions as I go through them.
Sure.
But it sounds like it should be pretty straightforward.
Yeah. Yeah, I mean, I mean, it took months of a group of us to come up with these forms. And so, I mean, I don't think we're going to expect that the board has to review them in the detail that the subgroup of staff and board did. You know, this was a team effort. A lot of staff put a lot of work into this.
A lot of hours,
And
yeah.
a lot of hours,
understand that.
and 2 board members as well. So, and, you know, we had input along the way from various stakeholders, such as other state agencies and RPC representatives. So.
Understood. Thank you. And I know I I know you've been telling us all along this work has been underway, and thanks for all the hard work. And
Mhm.
it's a good milestone that it's done and out there and numbering nailed down, and that's
Yeah.
great.
Yeah. And then, these are as it, Rutland, Rutland's executive director, I talked to him last week, when I was in Rutland, and he's excited to be the guinea pig. And, these forms, they may change over time. As we learn, how this is all gonna work. But I don't think that it requires a board approval every time that we modify one of these forms. We will keep the board apprised, and as we have been. But the guidelines, of course, those were approved by the full board. The only outstanding issues with those were the final formatting in terms of the section numbering and one detail around digital GIS submittals that actually isn't quite finalized. You'll see if you look at the final form of the guidelines, it refers to an attachment B. And so we will need to develop that attachment B as a subcommittee of staff and board, work with ADT on the digital submission requirements.
Yeah.
Any other questions or comments about the regional plan application guidelines or application form or comment form at this point? Oh, Sarah, sorry, your hand's
All
up.
right. So I think you already said a lot of it was a huge group effort, and thank you to all the staff for boldly going into this new frontier, creating new numbering for our guidance. I think the other thing that I'll note that isn't on the website but is still being worked on in the background is the application guide. And so that has been stood up. There is a draft which we're going through now and cleaning up, and eventually that will also make its way onto the website, which sort of gives a point by point of how to fill out the application. And so I think too, there's some other technical filing work that Aaron Brondike needs to do with the new forms that he will do upon his return. But so still a little bit more to come, but this was a huge lift just to get here. The end of last week, we weren't quite there yet, but just within the past couple days, it's been nice to see this get pushed across the finish line. So kudos, Janet. It's nice to see this finally up and online, and it's been a huge lift.
And again, thanks to all the staff that put their efforts into this, and in even, this information got put on the website in the last half hour before we had a meeting here. So thanks to Maddie for getting that up too at the last minute. Kirsten.
So are you in the process of letting people know that this is now available?
Yep, here we are in a public meeting. This is, as I said, it just became available. And
Yeah.
I will be reaching out to individuals from the various regional planning commissions and our state agency partners and other interested organizations as soon as I can. Yes.
Yeah.
So if there aren't any more questions or comments about regional plan applications, we could move on to a report from Sarah on Tier 1A, relatedly.
Sure, which is going to be 2.0. Now that we have the finalized numbering system and conveyances, I'm taking that and starting to work on that process as well as the definitions. Again, still on target to hopefully have something to the board for mid-September with a draft for legal to begin working on by the beginning of September. So I think I'll speak to that, and I can just quickly wrap into Kirsten and I also spoke today about a timeline for the road construction jurisdiction guidelines, and have started to schedule some meetings around that with various staff, and also a timeline for the tier 2, recognizing that we are asking for a delay in that until the end of September. And to something in terms of welcome back, Alex, that's something that the board formally did request while you're out. I think it was the end of September 2026 for both tier 3 as well as tier 2.
Okay, Kirsten, do you have anything to add about your work with Sarah on tier 2 issues? Oh, your hand is up.
No, but I was just going to ask a question about, has anyone drafted a letter to formally ask for the extension on tier 2 and tier 3?
So that is something that I will be doing. I haven't had a chance to do that yet.
Okay. Just want to make sure it's on someone's radar. No, I don't think I have anything to add beyond, as Sarah indicated, we have met a couple times and sort of mapped out an approach and initial plan to the work. And so we'll update you as we have more substantive information to share.
Thanks. Alex, you have a question for Sarah or Kirsten?
More of a comment. So with regard to the road rule guidance, I like the schedule you've mapped out for working on that, and I like the fact that you're going to talk to staff first. I just want to emphasize that because I was reviewing the minutes from the prior meetings, the last 2 that I missed, and there was some discussion of, trying to tap existing stakeholders for some of our other work. And the impression I got is that you're going to seek to get our own staff's input first and maybe have some more board discussion before reaching out to stakeholders. And I would endorse that. I think that this particular effort doesn't need to start with stakeholders. I think it really should start from our own program. And then, once we have our ideas about what the guidance should be on the road rule, to get some input from folks afterwards. I would also just remind you that I think I mentioned this a while back. With regard to the tier 3 work, I posed a question related to the road rule to Rebecca. This was months ago, specifically asking her to look in statute for definitions of the words road and driveway, because they're used differently in the road rule. And so she did do that work and didn't come up with too much in terms of other statutory references that really define those, but she did come up with some information. So if I didn't forward that to you, or you don't have it, ping me outside of the meeting here and I can provide it. Rebecca would have it as well, just so that those items that you talked about in terms of clarification, maybe that's another one that we could add to the list and just leverage the research that Rebecca did a little while back.
Thank you, Alex.
Thanks for the reminder, Alex.
Kirsten?
Well, yeah, so also, Alex, Jenny had made known that she had some background information that she thought would be helpful and relevant. So that's one of the staff meetings that we're scheduling to connect with legal through Jenny. Yep.
Okay, Kirsten, do you have anything on wood products manufacturing rollout, recommendations rollout?
No, nothing,
Okay.
nothing new, but I do want to remember at our agenda setting meeting to get it on the agenda because
Okay.
there are some things that I want to share with the board for just an update and opportunity for input, but not at this time.
So all 5 of us will remember that on Wednesday, except that I won't be at that Wednesday meeting.
I
but-
also will, I'll mention, I see Billy's with us. Billy, on behalf of ANR, sent a very thoughtful, you know, sort of overview, ANR perspective concerning the 10 action items that are to be taken up as a consequence of the report. And so Billy, thank you for that. And that's part of what I'll be going over with the board.
Okay, Brooke, do you have anything on appeals to report today?
We have an hour scheduled for that discussion.
Oh, that's
in just
right.
A little bit.
And then let's go to Alex on tier 3 and 8C.
Right, so the update is on tier 3 is that we had another stakeholder meeting August 8th. I've been away for a couple weeks, so I haven't had a chance to summarize that and get you the summary, but I'll be doing that later today or tomorrow. And it was productive. It was not as well attended as some of the others because, you know, we had hit the magical August date when folks do take some vacation around here. But I think it was still productive and helpful. And so, like I said, I'll be providing all of you a summary of that so you can see where the conversation is going. And per what I outlined previously, my game plan is to come up with a memo that makes recommendations about changes to the first draft based on the feedback from both this board at several meetings worth of discussion, staff, as well as the stakeholder group. With the current plan is to have us discuss that memo and the next step forward for the second draft at our September 4th meeting. In addition to the August 8th stakeholder meeting, I'm trying to remember the days now. I think it was the 2 days prior at the all staff meeting. We went over the first draft of the tier 3 rules and gave staff an opportunity to ask questions and to provide comments. And so that was super helpful and, you know, got some comments after the fact on that. I encourage staff to contact me, you know, outside of the meeting if they were more comfortable having a conversation about it that way too. So there's a lot to summarize. And so I'll be doing that through that memo and getting it to you in advance of the September 4th meeting so we can take the next step forward on that with regard to tier 3. Again, the hope is that we'll be able to have a decent second draft in September so that we can go to public outreach, more formal public outreach across the state in October. As far as 8C rulemaking, I think it was the July 31st meeting where the board sort of gave the head nod to the tentative stakeholder list with a couple of recommendations for additions. So Kirsten and I are going to get together and formalize that. And the game plan for the kickoff for the 8C rulemaking work with the stakeholder group is tentatively late September. So that's sort of where 8C stands, and Kirsten and I will be co-leading on that. And so we'll have to get together, Kirsten, sometime soon and make sure the original schedule that I built makes sense to you and that we flesh it out with probably an extra meeting or 2 for the stakeholders, as I had only scheduled 2 originally, and I'm sure we'll need more than that. That's it.
All right, thank you, Alex. Any questions for any board members on any of these tasks that we have been working on? Okay, hearing and seeing none. Let's go on to item G, which is a discussion of the appeal study. Brooke.
It's going to take me just a second to share, since I'm sharing the computer to share.
Okay.
If you need help.
I just emailed you a PDF. That would be much easier if you could share that. It's the last email I sent that says use this one. Sorry, folks, if you could just bear with
It's okay.
us.
Yep.
We had a little issue trying to save the Excel spreadsheet. It kept not liking it for some reason. See if I can do it. Okay.
Okay, we see that.
Okay, great. And now the last time that, last week, for Alex's benefit, we did discuss whether or not we could, in addition to taking Act 250 appeals of JOs and permitting decisions, not enforcement, to leave that with the court. We also wanted to explore whether or not we had capacity, timing, et cetera, to take on some municipal appeals in the municipal arena. The municipal appeal docket is about 60 cases a year, give or take, and about a third of those, you're sort of in the 20 case area for ones that have been indicated and assigned sort of the housing component by the environmental division when they gave us their statistics. So I went into all of the cases that were municipal housing for 2024. And
Do you want me to scroll through?
yeah, so let's just look at them don't move yet.
Okay,
Let me just
all
go
right.
through them one at a time very, very quickly. We had a number of STR where somebody was changing like an accessory dwelling, maybe an apartment over a garage, that kind of thing, in order to have a short-term rental. So the first one ended up being that very thing. And I also, in the notes section, indicated how the case was disposed of, whether it was by settlement, stipulation, et cetera. And before we go through them one by one quickly, I do want to say that it does appear to me from the review of these cases that most of them were appealed by neighbors. Most of them were subdivisions or single family homes. And in fact, we only had one large housing development that was appealed in this grouping for the cases that were disposed of and adjudicated in 2024. So we had this first one, and I'm sorry, it's a little bit hard to read them. But if you look at the docket number, that's typically the bottom line of the entry. So we have that Fuller Bridge Road conditional use denial. That one resulted in the stipulated settlement. Then we have a Chemo Heights 8-lot subdivision. That was a denial. It ended up stipulating and they got their permit. In the Stanton McDermott, you're talking about another STR. The 2438 Mountain Road PRD, that was a 9-unit planned residential development, and they were requiring a waiver of setbacks. And that one, in fact, did go back to the town on remand. So I don't know the ultimate, what happened after that. Then we had a 3-lot subdivision with single-family homes. A merits decision came out of that one, upholding it and giving them the permit. Again, it was neighbors and that was represented. I'm sorry, the wraparound didn't work properly on the column that says who appealed it. But that one was neighbors represented by an attorney. Then we had another subdivision, 7 lots. That one was withdrawn. They decided to do something else. We had a subdivision, didn't indicate how many units. That was a decision on the merits after a site visit and a 1-day hearing. We got a variance denial on a single family. There's Alta Assets. It was the first time up to the court, single family dwelling. And we had a variance request on another subdivision, did not indicate in the appeal documents how many units.
Can I skip over?
Yep.
Yeah,
Keep
sorry.
going. Then you got Okemo Heights. That was an 8-lot subdivision. You can go down. Oh, wait a minute.
Yeah, no, I think
Where are
it
you?
just
You already
kind of
went
jumped
there?
from
Okay, there it is.
the,
Yeah, you can, I don't know where we are. Wait a minute.
yeah, no, I don't think you went through these yet.
Can you go up just?
Mm-hmm.
Yeah, stay there for a second. So the Stanton McDermott is an STR. Then you had a Mountain Road PRD. Lemelson 3-lot subdivision. It's just single family homes. Again, that was neighbors represented by an attorney. Get another 7-lot subdivision, 9 Hearths Drive. That was another appeal withdrawn. The person did not follow through and show up at court to prosecute their appeal. The Laster subdivision, it was on the merits. I don't know how many lots there were. Then we had a height variance for single family home. So what you can see from these, we're talking mostly single family homes and accessory dwellings or STRs. The subdivisions, I didn't see any that were for anything other than single family homes. Go down one or to the bottom. Keep going.
There's a 30 unit.
I lose any? Did I lose any? So then we get to the big one. That's a 30 unit. It was like an apartment building and another small area that had some other units. And that was denied and the applicant appealed it. It did not conform with the zoning ordinance, but they ended up with a stipulated judgment after a Supreme Court appeal. So the project did go forward, but it went all the way up to the Supreme Court.
Sarah had a question.
Sarah?
So a couple of things that would be helpful for me, it looks like you have this and can share the document with board members. Couple of questions. What's the time frame? I'm seeing 23, 24. Is this just for a fiscal year, a calendar year?
These are fiscal year cases that were adjudicated and disposed of. They finished during 2024. So the docket number is just the 23 just indicates it began in 2023. That's how they start the case numbers. They start it with the year that it is filed. So,
Next,
but these
question.
are just this is the universe of cases that were decided by the court in 2024.
And then I think to further distill it, if any of these are priority housing projects, I can tell that at least one of them, just from the name, is affordable housing, but I'm not sure if we were able to determine if any of these were priority housing projects.
You know, I did not see any indication of that. I mean, I spent about 10 minutes on each case trying to look through the court decisions, the statement of questions, that kind of thing. None of them specified it, at least in the introductory, this is a case about. But the 30 unit housing project, that Bourne final plat application, it was a subdivision for, that was the only large one that was finished up yesterday. I mean, last year, not yesterday, last year. We do know from our own research under Act 250, there was one priority housing project. But that was on the Act 250 side during this time period.
These are all
So,
just municipal, right, Brooke?
Yeah, this is only the municipal arena to decide, all right, what are the housing related cases, which is a third of the docket, to try to see, is there a way to speed up by taking the housing appeals or some portion of them for the larger projects? And what we're seeing is, at least currently or in the past, we're not seeing a lot of appeals of these larger projects. Sarah?
So just to also further clarify, any ones that also had an Act 250 related, that were somehow, there was also an Act 250 appeal with, were removed from this list, so this is just purely ones that had municipal only? Is that correct?
Well, if they're, I didn't cross-reference them to docket numbers for the Act 250 cases, so I do not know which one of these, if any, were appealed on Act 250 or even were required to go through Act 250. I don't know the answer to that, but we can certainly compare them.
And then these are just ones that began as appeals and aren't necessarily enforcement cases, correct?
Right, yeah, we completely left the enforcement cases aside, and those will be continued to be adjudicated by the court. And on Act 250 enforcement, we will act as prosecutor still, and then the towns, of course, play that role on municipal enforcement.
Thank you.
So
Keep going down.
yeah, so what, you can go down. We don't need to go through each and every one, but as you can see, they're
The end
either
of it.
small lot, 7, 8 lot subdivisions, or single family homes. That is the majority of these appeals, and more of them than not are being appealed by neighbors pro se. A couple of the neighbors have lawyers. So I'm not sure where this kind of leads us to. I think that the notion of being able to adjudicate the larger projects, certainly those are the ones that need to be sped up or dealt with more expediently. But we're just not seeing much of a volume of that. Whether that will change with the alteration in our jurisdictions.
Thomas
Who's
always
to
had his
say?
hand up.
Oh, Thomas, I'm sorry. Thomas would like to speak, if that's okay.
Go ahead,
Darren.
Thomas.
Thank you. Brooke, I think I missed it. How many total are on that spreadsheet?
I didn't number them. I kind of lost count as I was working on them, but let me look real quick. I have a paper copy. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 19, 19.
Thank you.
Alex.
Alex?
Look, this is just 1 year, right? This is just one snapshot, 1 year snapshot.
Yep.
So I think that making generalizations about the size of projects with regard to which ones get appeal and whether or not the large ones do get appealed, it's a little hard to make those generalizations from just one year. It's still helpful to see the numbers, so thanks. But yeah, I don't know that this year is indicative of all years. And I say that because larger projects tend to be irregular, sporadic, at least in my experience. And it's not like you're going to get a 70-unit project every year, across the state. They can sort of come in ebbs and flows.
Right. Now, we had looked at, we reviewed it when you were gone, the municipal permitting appeals for the last 3 years in terms of just the numbers, and they were very consistent. Had I not actually taken the weekend off, I would have looked back into 2 other years prior, and I can do so. I had the sense based on this and the percentage of the consistency in the numbers in terms of their percentages. And then we had our own data that Jenny had been keeping track of for the past 2 or 3 calendar years. We have all of the Act 250 appeals and how many were related to priority housing. And it was only 1 per year for the last 2 years. But if you feel like that would be a more complete picture, happy to do it. My sense is, from what I have seen in the Act 250 arena, I don't expect them to be widely divergent, but I'll be happy to go back and look at that further. And I'm sorry that this is hard to read.
Brooke, that's not necessary. I just wanted to make the comment. Since I reviewed, the discussion at the meeting that I missed, and I've seen your data on the number of appeals in the various categories. I guess what I wasn't clear on from the meeting I missed is what are we trying to learn from this breakdown that you've done from this 1 year? Were we trying to get a sense of size of applications or something else?
I think that this helps us to figure out if we were to take housing appeals, would that be helpful? We were trying to figure out what could we do with the capacity that we have, which right now is zilch, but over time when our other tasks are completed, how could we assist in terms of the housing crisis and moving those applications through the appeals process quicker? And so I thought it was important to figure out, well, if this is just, a bunch of appeals on a single family home, which many of them are, I don't see that as adding great value to worry about those as opposed to the larger projects. Maybe we talked about maybe we should consider taking the larger housing projects, over a certain number of units or over a certain number of lots. Just trying to get a sense of how could we impact and effectuate the housing appeals that are really being held up with these on the municipal side.
Sarah?
I think I'll reiterate a little bit of what Alex said very well, which is I don't want you to spend a whole lot more time on this. I think this was a byproduct of our previous conversation in terms of just, as you said, fleshing out a bit more of what is the scope of municipal appeals specifically around housing. But I think what I'll reiterate is when we have discussed this before, the municipal side, it has more appeals than the Act 250 side. There's a substantial number of them, not just on the actual appeals process, but in terms of enforcement. And I think what I'll reiterate is, as a board member, I don't feel like this is an area that we should necessarily be going into. I think that we can take a look at the charge that we've been given as a board in the reshaping of Act 250 under Act 1A1 and the ability with Tier 1A to take and Tier 1B to take a look moving forward. And if we are going to do something, that it be specifically geared towards priority housing projects and or those areas that have achieved that Tier 1 status and housing projects within that, as being moving forward, what would help the best in terms of expediting housing appeals. I think that the information that's presented to me today, there are some affordable housing projects in here, but they're so scattered, so diverse, so sort of smaller number, that I think the more consequence that we can have on positively effectuating the appeal process would not be necessarily to take on all municipal housing appeals, but a very targeted portion of it. So thank you. I think this information is helpful in terms of focusing the conversation and to Alex's point, we could go back and look over subsequent years, but I don't think that's necessary at this time. Thank you.
Great.
Before I go to Annette, I just want to reiterate what Sarah and Alex are saying. And I think that what this does, Brooke, is it helps us, it sort of confirms that idea that, yeah, maybe not all municipal housing is appropriate to come to us if we want to assist in the housing crisis, but that that there are ways that we talked about that could be more targeted, and whether that's multifamily, whether it's priority housing, whether it's affordable housing, or tier 1A and B projects, I think we should continue to discuss. Before we go to Annette, can I go back to Alex?
Thanks, Janet. So I like this idea of using us as a way to address the charge under Act 181 to deal with housing appeals and how to try to expedite them. And I like the conversation about how to do that in a targeted way rather than just taking all of the municipal housing appeals. Because like you said, Janet, Brooke, this information was helpful. And I think, you know, us taking over an appeal for us, you know, the conversion of a short-term rental, there's not a lot of value there. My question is, did you talk at all last time about possibly tying our adjudication of municipal housing appeals to something to the future land use areas? Like, I know you talked about possibly in tier 1A or tier 1B areas, or perhaps multifamily or affordable housing or priority housing. What about the future land use areas, particularly those future land use areas that are meant to be where we want housing, regardless of whether they've achieved a tier 1A or a tier 1B designation?
We didn't go there in our discussion last time, Alex. We could go there now.
I'm not sure if it's the right way to, you know,
Yeah.
worth going, but it strikes me that there's a lot of work going into mapping these future land use areas. And there are a lot of rural communities that are not going to be able to achieve a tier 1A or a tier 1B designation in the near term. And yet to sort of have, to not discriminate from a geographic standpoint across Vermont, to allow all communities to be treated similarly with regard to housing appeals and the emphasis on getting those figured out more expeditiously. Maybe that's something we could think about. I
It
think the
goes
problem.
along, I'm sorry, it's something that we added a particular question to the comment form about, because the statute asks, or the question is asked, do these areas accommodate the housing targets that the regional planning commissions have to municipalize for each municipality within the region? And by these areas, we mean village centers, downtown centers, village areas, and planned growth areas. So I presume those are the areas you're talking about, Alex?
Yeah, I didn't spell them out, but you
Yeah.
nailed it. Yeah.
Yeah. So yeah, I'm sorry I interrupted you to answer that, but go ahead.
Well, I'm just thinking out loud, which is terrible to do in the middle of a board meeting, but this is how we work together with this crazy system. So the problem with what I'm suggesting, of course, is that in the more rural communities, we would then see a bunch of appeals of single unit projects, because that's what's happening in a lot of rural communities. So, you know, that's somewhat problematic. The other thought that was going through my head simultaneously was, if we were to propose to the legislature that we take Act 250 appeals, both of jurisdictional opinions and of land use permits, you know, that's help me out, Brooke. That's like, there's like 67 or so, 69 appeals per year, according to your numbers. And the Act 250 JO and land use permit numbers are what, like 14 or 15 per year generally?
Yeah, I think the average was 14.
12 or 14.
12 or, I think it was 12.
Yeah, so
something like
I'm
that.
bad with percentages on the fly, but it clearly we would be taking a certain percentage of the overall appeals away from the court. And I would assume that that would enhance the court's ability to clear the docket in a more timely fashion. Brooke, what do you think of that? Do you think that the removal of whatever percentage that would be would help the court move the rest of them more quickly?
I don't think it's a large enough volume to make that much of a difference. And so many of them result in stipulated settlements. It's not like, they're all going to hearing or anything. So that's why we were trying to contemplate. I mean, if you're going to construct us to be able to adjudicate appeals because we have structural changes to make, it seemed to me that docket is certainly, it would be good for us. I think that we could do a good job with appeals, but I am concerned that setting it up to be that different structure for too small a grouping of cases may not be financially sound. And we still are not addressing the housing crisis, which really is of concern. So the notion of taking the Act 250 JOs and permitting, plus pulling in some of the municipal docket, that to me would make more of an impact on the court side, because I think that would reduce their docket more. But now looking at the actual cases, I think that we should go with some kind of, like priority housing, number of units, actual projects that are not these single family home situations where primarily it appears that they're neighbor disputes. From my reading of the decisions and stipulations where things were withdrawn, et cetera. So I'm trying to find enough volume in order to make it worthwhile and efficient for us to step into a different role for our cases. And I feel like we can slim down the timing on it.
Yeah. So I just want to reiterate something I've said before, which is I think we're all on the same page. I hope we are, that it seems to make perfect sense for our board to adjudicate the first level appeals of Act 250 related matters. And I'm still really nervous about dipping our toe into doing that for municipal appeals. And so the thought of doing it for some municipal appeals, but not all municipal appeals, is attractive to me because it's a way to address the housing issue in the manner by which you were just speaking. But I'm still a little nervous about it. And yeah.
How so, Alex? What concerns you about it?
Well, as we've discussed previously, Act 250 has a set criteria, review criteria, and rules that apply statewide. And municipal zoning is not that way. Every community crafts their own zoning regulations with their own special twist in order to serve, their community or the time in which they happen to write them. It may not even be related to their community. It's just the vintage. And so, we're talking, I don't know, over 150 different sets of regulations, zoning, subdivision, official maps, you name it. They're all different regulatory documents in play. And yeah, it will be a lot for this board to have to understand each and every one of those in order to act as if it were the local review board and make a decision about an appeal of one of those projects. It's not that we can't do it. I'm just nervous about it. But I appreciate the discussion you all had last time about like, okay, if we're gonna recommend going in that direction, why don't we do it in a way that will make the most difference for the housing issue? And so I appreciate all these ideas about different ways to do that.
So Kirsten has had her hand up. Kirsten?
Yeah, I can see from this 1-year snapshot that there's a certain scope of these municipal housing appeals that are the sort of one-off, one unit. One of them was even an awning, neighbor dispute kind of thing. But I think if the whole premise of this is to speed up appeals for housing projects, then I would not myself be enthusiastic about limiting it to PHPs or housing projects located within the certain, tier 1A, 1B areas. I think that, even Alex, you weren't here last week, but I was saying in my mind, a 4 or 5 lot subdivision in, say, Troy might have some equivalency to like 100 unit project somewhere in Chittenden County. So even these small unit projects can be very important in particularly rural areas. And in my mind, I'm kind of thinking about this, like every unit matters, like that's a home for someone. And so let's do everything we can. So that's kind of in general where I'm coming from. But I understand that, the desire to maybe kind of look at a subset of housing. But I just want to be, if that's what occurs, I want to be thoughtful about how that line is drawn.
Kirsten, the idea of using the future land use map or future land use categories as a trigger, perhaps, because those 4 that I listed earlier, those are supposed to be the areas that take up that housing target that the municipality is basically given by the municipalization that the RPCs do from the statewide housing needs assessment each year now, or each few years, not each year, but does that, so that in Troy, that might capture the important, number of units in Troy in those areas.
If that future land use area is located in most every town as it's supposed to be, then yeah, I would be more supportive of that concept than having it predicated on, must be tier 1A or 1B, or must be a PHP, for instance. So yeah, but I think, we could also look at, minimum number of units, minimum number of housing lots, that kind of thing. But I could still be, I kind of like the simplicity of just all housing appeals, like if the premise is to speed them up, we'll just, send them all in one place. So that's just my own
Sarah?
2 cents.
Thanks, Kirsten.
I feel very strongly we should not be taking on all housing appeals. And just for a quick second, I'll deviate and say that I think the board hit the ground running. And one of the things that we haven't been afforded is the ability to have a strategic plan of how, once we get through this sort of initial startup, we are going to spend our time and on what areas of our importance. And I think coming into this organization, one of the things I've seen that we could have a huge impact on housing as well as other things is just going through a really good housekeeping of our existing rules and guidance and policy and revisiting a lot of those documents and procedures that we have in place. And it would also help us sort of figure out what are our priorities in terms of what we're going to spend our time on in the future and trying to actually implement the thought process of Act 1A1. We have regional plans to approve. We are going to most likely be taking on some of the appeals process. We're going to be approving tier 1As and tier 1Bs. There are a whole bunch of things that we're not sure how our time's going to met out yet and how much time we're going to spend on each one of these items. And I think if we simply take a wide swath at something, that doesn't give us much flexibility in the future to adapt. And so one of the things I'll speak to in terms of why I don't think that we should be taking on all housing and we should be very strategic at this point is we can always increase more. If we see some success as we stand up these tier 1 areas, and we see what the impacts are going to be of having areas that don't necessarily have Act 250 and it's just the local permit process, which might actually create more appeals on that local permit process, is we could always take on more. But I'd rather not take on everything and then have to scale back. I'd rather start with something concrete and adapt it and grow it. And also take a look at, hopefully once we can take a step back from the immediacy that we're under, where we should be focusing our attention in terms of the overall organization, the health of the organization. So that's just one of the things where I just as a counterpoint to Kirsten, feel very strongly that we should not be taking on all housing at this time. Thank you.
Thank you, Sarah. Before I go to Alex, Annette, I know you have your hand up and I intend to get to you, but I want to let the board have its discussion first, if that's okay. So Alex?
Right. So I would second Sarah's notion of a little bit at a time. If we're gonna, again, this is a report. We're making a report to the legislature. They will ultimately decide how to deal with how to reform appeals and where they go. But I'd be more comfortable recommending that if our board is to take on some appeals, that we do it a little at a time. And I really respect Brooke's point about like, well, why do it if it's so little, that you have to create a whole new system and you haven't taken enough appeals to sort of warrant that. And so I'm thinking about that, Brooke. But at the same time, I do like the, little bit at a time, add to it as you show success and efficiency. And I think a lot of this comes down to a basic question that anybody should be asking us, and we should be asking ourselves and reporting to legislature. Can we do it faster? Just because we switched appeals to our board, will we be any faster than the current environmental division? When we look back at the data from the e-board, a lot of the timing was the same. And so, yeah, we're going to hopefully, if we take on appeals, we're going to recommend ways that we can do it better, faster. But I'm not convinced that we will until we actually have some experience doing it. And that sort of buttresses Sarah's argument about like, how about we do a little bit, recommend doing a little bit at a time, make sure we get our wheels underneath us as an appellate body. And then once we demonstrate that, oh, we can adjudicate these things, much more expeditiously than the court, the legislature can give us more. Yeah, so that's all.
And I guess just before we move on, I would also agree that we don't want to take on all of it initially. I don't see how that would be a good idea. Brooke, do you have further comments before we open it up?
Sure. And there are two other issues that I did want to talk about if we have time. But we can go to an end in just a minute. I just wanted to circle back with Alex's concern about all of the zoning ordinances. And, that's something that we deal with. We have, Title 24, Chapter 117 has, if you're going to do zoning, you have to do these sections this way, kind of. There's some stuff that's prescribed, which is very similar from town to town. But, even though you have different versions of zoning, they're all very similar in a sense. You have permitted conditional uses, you have a use chart. And so to me, I have never perceived that as a concern, either as a practicing attorney or for the court. I mean, the judges don't know any of these ordinances by heart. Even, though I may have dealt with one 10 or 12 times in practice, we would always go to that body of law. And it's more of a task, right? It's interpreting and applying that law to the set of facts. So I have great confidence. You guys, I mean, our board has such great intelligence and experience in this. I have great confidence that we would be well suited to be able to do that. So I just wanted to put that on the table because I know it's, now, having said that, my biggest concern are the legal challenges, right, that need to be researched and then written, and what composition or what support staff in terms of legal do we need, and those kinds of things. So just on the issue of could we speed it up? Remember, we're comparing a different system with some of the statistics that we have from the environmental board on processing. And, as a volunteer board and things did, we're talking about having a new set of rules where we would slim down to very bare bones any kind of discovery. You got to tell us what you're going to put into evidence ahead of time. And so there aren't those delays pre-trial, basically, for discovery and for motion practice, which I'm still trying to get some legal minds to focus their attention on. Under the APA, why was it, first of all, that the environmental board didn't have motions flooding in all the time? But how can you confine that kind of practice? So those two pieces are still important that we need to further analyze and consider to figure out if we can do it faster. Because what would be the point if we're not addressing that problem, right? So I appreciate all of your thoughts very much. And I'm going to stop there because I do want to talk about two other issues, like the standard of review and election to consolidate, but they will go very quickly. So I'd prefer to hear from Annette, and then I could switch topics.
Okay, Annette,
Sarah.
go ahead.
Oh,
So going back to that list of appeals that you were looking at, I wonder, since you reviewed the cases, did you identify any sort of common thread in the basis for the appeals? I don't have a lot of experience with municipal appeals, but through the appeals work stakeholder group, I think I recall that there are two categories. So was there anything that you noticed about the reason for the appeals?
Absent a denial to the applicant where they just, flunked on some issue, setbacks, whatever, it appeared really to me to be neighbor disputes. I've heard that referred to quite a bit during the study. And unfortunately, I think that, this is the mechanism through which neighbors are able to get concessions on conditions. That's typically what the settlement agreements were trying to accomplish was, okay, neighbors upset about the project and it's okay because we're going to move it, one was a move it back a little bit farther kind of thing, or buffering. So honestly, to my mind, the majority of this really is neighbor disputes, neighbor unhappiness. And unfortunately, those issues could not be resolved before actually getting to the court.
So it wasn't about
Only one,
lack of compliance with the zoning ordinance so much as just not being happy with the project?
well, the challenges were made to the zoning ordinance, but most of them resulted in a stipulated settlement. So which way it would have gone, I didn't have time to really analyze or really
Okay, thank
understand.
you.
Yeah, but
Sarah.
it was.
Oh, sorry. Go ahead, Brooke.
No, I was a little bit surprised because I did not think it was as much, I don't want to use the term NIMBYism, but it did seem like there were issues that, for example, in a board setting, if we had a mediator and these kind of neighbor dispute type cases could be sent to a mediator that didn't charge, $300-400 an hour, have that sort of mechanism built into our process. At court, you can do mediation, but you have to go hire a mediator for a large sum. So that was another component we were considering. But let me leave it there for those issues and just, oh, Sarah, sure. Didn't mean to
Just-
cut you off. I forgot your hand was up.
That's all right. I just wanted to chime in because I think there's some board discussion about doing things faster, but it's also better, not just faster, and some concerns around that. And I think what we heard from the stakeholders group, I think it's in your notes that there are actually some participants that are advocating for keeping things the way they are. And I think the environmental court has grown and really solidified over the past several years and as continual improvement. And to Alex's point, which he raised earlier, I think we as a board, when he wasn't present, had a conversation about rising tide lifting all boats. If there was less on the environmental court's docket, it would actually enable them to go at these things at a better pace. And they're becoming a well-oiled machine at this point that might do things faster and better. I think the other thing too that I want to bring to the conversation that we haven't talked about, and just to put a pin in this, is the idea of standing, particularly with these smaller housing projects and the characterizations that are being made about, well, why was there the appeal? Who were the people that were doing the appealing? That I think there's an opportunity to try and effectuate these things positively, maybe by looking at standing in these cases more so than just changing the entirety of the process. So just a few thoughts to sort of put out there.
Elaborate on that last one, Sarah.
So I think within the appeals process, and Brooke can speak to this, I think there has been brought up by the stakeholders in terms of who has standing to be able to appeal on housing projects. And maybe if we could take a look at refining that, it might try and lessen the number of appeals that are occurring just simply because somebody doesn't want to see a project occur next to them or something of that nature. And there are other tools I think Brooke was going into about mediators, but this might prevent things from even getting to that point if we were to take a look at redefining who has standing to appeal.
Okay, thank you. And
How do
Brooke, you have two other.
Can I ask, how would you want to redefine that? Because this, this was before the legislature this past session about petition standing. Are you talking about for municipal appeals? Or are you talking about like across the board? Because, the problem with standing is it's a constitutional dimension in terms of the government acting to take property is really what's at the basis. Are you harmed, or is your property harmed as a result of the government action? And so that's tied in with being able to demonstrate an undue adverse impact to that person. Now, in petition standing, it's just a group of people, I think one person it's just a group of people. You have to have the requisite number. And we've debated this back and forth, and this is an interesting debate because it's like, why should a group of people who are not impacted and can't demonstrate that they would be harmed, why should they have standing? People used to call it the mob rule. Oh, get enough of your friends and you can stop somebody on the other side of town doing something. But the reason why it's important is because sometimes towns don't make the right decisions. In fact, sometimes they make illegal decisions or really bad decisions that if they're not appealed and there's no ability to say, hey, our town did not apply the law legally or properly or whatever the concern is, then there's no watchdog to be able to do that. And these people get a permit even though it's not in compliance with law. So those are the two sides of the debate. I was very convinced, it sounded good to me that, okay, you have to be able to demonstrate that you will be harmed. That's how you have an interest in this project. But that other notion of, you know, a runaway board, boss hog justice, we don't like you here in town because, you know, whatever bad reason or discriminatory reason, if there's nobody there to address that and permits are given without the law being the integrity of the law, that's why this is a watchdog provision. Sarah?
I'm just going to disagree with that. And thank you for clarifying about standing. I'm familiar with that too, but just it have been, and I think a lot of improvements made by the legislature in the past few years regarding municipal ethics and state oversight, how that's staffed and the ability to enforce behind it, I think has yet to be seen, but there is an arm now to deal with municipal ethics complaints, to your concern, but just being somebody that is very familiar with the municipal side of things and zoning and the variety of zoning regulations, the variety of boards and their staff people too, is I think while there are errors sometimes, that there are a lot of well-intentioned people, and just to speak to that in terms of you know, sometimes there are mistakes made, but generally there's not complete malfeasance to that point, and that there is a separate process for that now. So I don't think that that's necessarily something that we need to be predicating our decisions about the appeals process on. Thank you.
Alex?
Well, I this is not my position, just to clarify. I'm giving you both sides of the story, that's all. I'm not advocating for one versus the other. I'm not sure what
Yeah,
to do. Alex?
So my side of the story is that I think that standing issues have been, as Brooke said, sort of bantered about by the legislature for the last number of years. And it's largely been about the petition, you know, group. And what I heard Brooke say at prior meetings is that based on her review, and maybe this was just a sense from more than just Brooke, that there weren't that many appeals that come from groups petitioning for standing, that most of the appeals are immediate neighbors that have a beef with the project or with their neighbor or with both. I'm not convinced that changing the petition side of the standing question, which is what the legislature's been most sort of focused on, is going to make much difference. And Sarah, I'm curious for your perspective on whether changing standing with regard to an immediate neighbor who feels aggrieved, whether there's even a way to tackle that, because my experience has been that it is often a neighbor dispute, but that if a neighbor has got enough gumption to try to lodge an appeal, they're going to find a substantive reason within the review criteria that makes the case for them. So like, I don't know how we would reduce the number of appeals through standing, because like if we wanted to say, well, if it's just a NIMBY concern, you don't have standing, you have to demonstrate. They're always going to be able to demonstrate, you know, on whatever criteria they can find that there's a reason that the board should have ruled against the project. Is there something else though that you're thinking we could do in terms of that standing question? I don't know what it is.
Go ahead, Sarah.
So you know, I question about where we resource things. I thank Brooke for doing some initial research investigation into this, but how much do we go down the rabbit hole without knowing the details on the spreadsheet in terms of who actually appealed and why? You know, it would be interesting to know. I think there was a sketch plan on there, which seems like really too soon to be able to appeal something. You know, what were people appealing under? To your point, Alex, so people will find anything, but I think that would require a bit more research in terms of what did they appeal under? Did they appeal under, was it like a character of the neighborhood, conditional use? Was it traffic? Was it, you know, what were they appealing under? I think that that would be something to look at in terms of trying to go about it. But, yeah, I think without doing a lot more research, which I'm not sure, I think to points that we are both making, is it worth going down this rabbit hole further, doing a lot more research, where I think some of the preliminary investigations is that are part of the process in terms of restructuring the appeals process. I think if somebody else wanted to take a look at that other portion of it and say, you know, how do we stop these neighbor versus neighbor appeals? That could be a whole separate research project.
So, and the legislature did increase the number on the petitioning from 10 to 20. And it also disallowed housing appeals on the case of character of the area. So those are two relatively new statutory directives that may have some effect. But I think it is the case that there aren't that many petitioned appeals. I think I pulled Sarah and Alex as former, municipal planning directors. How often did that happen? And I think you both said rarely. And I think in my 8 years in Manchester, it was only once. So, so it is rare. And the one time that it happened in Manchester, it wasn't a housing issue, but well, actually, it kind of was. It was assisted living, so it was housing. But I kind of forgot my train of thought here. But you still have two more issues or one more issue, Brooke, to bring up?
Yeah, real quick. We've talked about the notion that if we were to take Act 250 appeals, then we would be splitting the opportunity for coordination or consolidation of appeals. And so we had discussed perhaps giving an election to the applicant only, of choosing to bring the zoning appeal over to us if we were adjudicating the Act 250 appeal. It would only be the applicant being allowed to do that. A neighbor could not, but that would be either before the Act 250 or after, whatever sequence that they occur in order to allow that consolidation to still happen so that they could have one trial conceivably and then get a decision on each of the bodies of law.
Kirsten.
Well, so because the municipal permitting often occurs prior to any Act 250, could the applicant elect to have the municipal appeal decided by the board or the court simply by virtue of there being Act 250 jurisdiction, not knowing if there's even going to be an Act 250 appeal? I mean, they could. Yeah. Is that how it would work?
I think so, because what if let's say the neighbors appealed their zoning permit, and so they're anticipating that would happen with Act 250 as well.
Yeah.
So I think regardless of the timing, if it's Act 250 jurisdiction, they have the election to bring it to the board on the zoning piece, assuming that they're filing an Act 250 act, which of course they would.
Right. If there's no Act 250 jurisdiction, this simply wouldn't be a path.
Correct.
Yeah.
Does that sound like, we were trying to make sure that this did not, it's very few cases that we've seen, a couple a year, that are coordinated or consolidated, but to make sure that that opportunity is not eliminated for the applicant.
Mm-hmm.
Does seem to be an
that.
issue that's important to various people, legislators, the governor, whatever, even if it's not really substantive, because it doesn't happen enough to make a difference. So I think that your suggestion is kind of an elegant way of saying, oh, we'll allow for that to still happen, but it'll be, it doesn't happen very often. And yeah, I like it. I like that as a way to try to satisfy that concern and move on to the more important elements of the appeal reform.
Mm-hmm. Any other thoughts on that one?
Yeah, I mean, I would anticipate it would be a pretty small number.
Yeah, from what we've seen at the court, it's like 2 or 3 a year, maybe. Something like that.
Well, so no, so do we know though, the projects for which there's Act 250 jurisdiction, how many have a municipal appeal? We should probably kind of figure out what that landscape looks like.
Okay.
Like, look, maybe, and I'd be happy to help do that.
Yeah,
Like, just look at the overlap between the,
Because Jenny
I-
has great.
just
it's called Calgary,
anecdotal-
you can compare.
Sorry.
Sorry.
Go ahead, finish that thought, Brooke.
I was saying, we can cross-reference, because Jenny kept the last 2 calendar years and she has case names. We can take a look at that to see how many are the potential anyway
Yeah,
for the last couple of
yeah, and I'll just say that anecdotally, whenever there was an Act 250 project in Manchester, and you know, the municipal permit was also was usually attained first. They were both appealed. When one was appealed, they were both appealed. And I know that from my involvement that, you know, there was some consolidation in those cases. Or I don't know, I may be misusing consolidation versus coordination, but you know, there are ways to, the court has ways to try to help make those appeals more efficient. So I think we could certainly try to do the same. And I like that idea, Brooke. I see
Great.
Sarah nodding too.
yeah, I do too.
Great, okay. Well, then let me throw one last issue at you, if we're okay on time.
Yeah, we are.
Sure.
Plenty
Okay.
of time.
The standard of review. I think we're at a point where everyone seems to be agreeable that we do want to start with the record. So we want the district commission, you know, all of the documents and recording of the hearing to be provided to us as a starting point, I think. And the question that I want to pose to you is, how much process do we want to contemplate in addition to the evidence that was put in below? Do we want a very narrow window, or do we want a wide open door in terms of like, well, you didn't put it in before, and now we're going to allow you to do it, but you have to have a good excuse, versus on the other end of the spectrum, bring anything that you want. And it's sort of like a de novo do-over. And so let me just give you a couple thoughts about that. Now, when we're writing decisions, you know, if you're doing an on the record review, you're basically figuring out if somebody made a mistake. So you're taking the actual decision and determining, is it okay or not? And then on de novo, you're just taking all evidence and then making a fresh decision. So the environmental board, that's what they did. They were a de novo review, just like the court is on Act 250. Yet I think that is, it's helpful in certain ways to the applicant and also to the neighbors or town. And the reason why I say it's very helpful to the applicant is many applicants don't want to spend a lot of money going to get their Act 250 permit if they don't have to. So they may not have to hire a noise expert. But if the case is appealed and the neighbors are concerned about noise, they may want to hire a noise expert to do that aspect and, you know, reach their burden of proof or burden of persuasion. And the other, so it's beneficial from the developer's viewpoint, not having to spend a whole bunch of money getting, you know, going in with a very well prepared but very expensive project in terms of permitting. only if it's appealed do they have to go that extra step and do, more to make sure that they got it locked down and they'll get their permit. From their neighbor's perspective, there's an application that's been worked on for a year or two or three, and they get told right before the hearing and they show up and they're supposed to say something. They may not have the opportunity to hire an expert. They might want to go get a different expert to say it's too noisy. So there are really good reasons why not making it on the record, that is a more expensive venture. And the other thing is that after our last board meeting, I got correspondence and had a back and forth discussion with Tom Little, D4 chair for many, many years and a lawyer. And he is extremely concerned that if we go on the record at the district commissions, and he has 3 recent hearings to sort of demonstrate, lawyers will come in, or the applicants will come in lawyered up. It will become more formalized, and it will defeat the intention that this was supposed to be, neighbors coming together with some expertise in a region and being able to have citizenry decisions made. It will change it into the new environmental division or something like that. And he's very concerned about the chilling effect that will have, and that it will be converted into a different process. So what do you guys think about that? How much do we allow?
Yeah, a happy medium. Can we have that, Brooke? Is there a model in state government?
I wouldn't say in state government that I'm aware of, unless somebody out there can point me to it. My idea, and this is conceptual, is to take in the whole record and then allow additional expert testimony with full disclosure so that it doesn't trigger discovery. And that means, I'm going to call Les Blumberg as my sound expert. He says it's too noisy. This is why. This is the information he used to produce his expert decision, that kind of thing. And then on the new evidence, you have to conduct a hearing. So we would be not deciding whether somebody made a mistake or not. We would be taking additional evidence and then making a permitting decision. That's the other line of demarcation I want to make. It's like, we would be another permitting authority making that decision, not de novo, and giving discretion from that on the record appeal. I'm working on language in that regard to try to explain it in a way that makes sense, that gives some deference to the decision below without turning it into an on the record appeal. We want second crack at the permitting decision, basically, not whether or not they made a mistake.
So what about if they have made a mistake as well?
Well,
like in some other aspect, like, I'm sorry, go ahead.
Yeah, it's more of, more on the de novo side, I guess I would say, in terms of the actual standard of review. We would be deciding the case, but we will give deference, and deference is only given if it's sound, right? So we might overturn their deference by saying we don't agree with them, but not like, oh, they made a massive error that's manifest injustice. It's not that high a bar. If reasonable minds could differ, but we think we're a lot more reasonable than them, we can change that determination, if that makes sense.
Alex?
I like what I'm hearing generally. I like Janet's comment of, we want the middle ground, and Brooke, the way you're describing it sounds good to me. That specifically the elements that I like about it are deference to the lower body, the permitting entity that issued the permit. So I've never liked the idea of a complete de novo review, especially when an applicant who may also be the appellant can change the project. I would like to have a system in which there's deference to the permitting entity whose decision is being appealed, such that we're reviewing the same project. It's not a tweaked version of the project to try to get around an issue. It's the same project, but the appeal is based on specific concerns. And that's what like you said, that's what we're there to adjudicate, is the disagreement about those specific concerns. So I think that's the right way to go. I really respect Tom Little's input. But I think we all understand that the process that district commissions like his make happen are very close to an on the record process to begin with. So I think what you're talking about, Brooke, meets him in the middle with that. It's like, let's respect the decisions that our district commissions, or in some cases municipal boards, have gone through, and let's ask for their decision to be entered into our process as an appellate board, not as an afterthought, but as an actual, yeah, we need to see that decision. And now tell us, what elements we're going to, talk about in some more depth, and maybe with some additional evidence. And the more I think about it, it feels like that's the court process currently, maybe without the deference part, but at the e-court, it feels like that's how the process works, right? The statement of question narrows down what the issues are. That's what the judge is interested in hearing arguments about. And although it's a fully de novo process, it is whittled down a bit. So I don't think what we're talking about is all that different, but I do like the elements that you pointed out, Brooke.
Kirsten.
Yeah, so as I've said before, I think I like the idea of starting with the record below and having the ability to add to it. And I guess the question I have for you, Brooke, is, in my mind, that's not on the record. You would be supplementing information on a case-by-case basis. And from my perspective, I think that it should be a pretty low bar. I think that there can be an array of circumstances whereby people want to bring forward additional information, and there should be some kind of standard that would need to be met. It shouldn't be wide open. There should be some standard, but it should be a pretty, like a comparatively low bar. But what I like what I'm hearing, and my interpretation of this is it wouldn't be on the record. Like, it's not on the record. So that's a kind of a question too. The record as it's comprised now throughout these, hundreds of annually decided Act 250 permit decisions, we have a record, right? We've got the recorded hearings, we've got all the evidence, all the exhibits are stamped, and we have a record. So can that record comprise the starting point for sort of this hybrid model that we're talking about, or what need be different, if anything?
Yeah, no, we take the record, but it's not an on the record appeal. We make up a name, or it's a hybrid approach where that comes up, and then additional information could come in. We have to define the circumstances and what. Mm-hmm. But the notion of deference, and Jenny, you jump in if I'm describing this wrong or you have anything to add, but when there's appeal from the environmental division, there's deference to the factual findings, but the conclusions of law are non-deferential. So that's sort of the additional minutia in terms of how you really apply the standards, so that you are giving the deference to the fact finder. Now, we give the deference, then we may get more information that could change that deference. And if we feel it's justified, sorry, we don't give you the deference because, and then we apply for the conclusions of law, which we are not bound by their analysis. So that's more of a breakdown on how it would work. And like I say, Jenny, if you're listening and I've missed the mark on that, please let us know.
No, I think the distinction between findings of fact and conclusions of law is the real critical one, and that you've got it.
Great. Okay, I got a pass fail. I got a pass today.
Maybe for fun, I'll just note that one of the rationales behind having deference to the fact finder on facts is, that they were there and able to see the entire presentation and judge the credibility of witnesses, etc. So there's sort of a distinction between that versus, the book research, which you can do completely fresh yourself. Just fun thought.
Great. Yeah. No, thank you so much. That's a really important reason for the deference, and yeah, credibility is everything.
Do we have more board
So-
comments before I recognize Annette? Go ahead, Annette.
I was very pleased to hear Tom Little's comments because I had the same reaction listening to your discussion last week. Let me give you an example of a case that I was involved in. It involved a mobile home park with a contaminated water supply next to a quarry that was seeking to expand. The quarry wanted to go deeper and they wanted to increase their blasting levels from 2,500 pounds to 8,500 pounds. I went to the site visit, and at the site visit, the residents of the mobile home park all came up to me and said, "Would you represent us? Would you represent us?" It happened that fast. Then we went to the hearing. The criteria were already limited at the hearing. Not all the criteria were on the table. I had done a review of the water supply division records and found that more than 30 notices of alleged violation had been issued and assurance of discontinuance, and the neighbors brought samples of their water full of rocks and dirt. The district commission required a test blast. For some reason, the applicant chose to blast only 3,500 pounds and not the 8,500 pounds. And so a permit was issued for what they demonstrated. The applicant didn't like that and appealed. The district commission also shifted the burden of proof from the neighbors to the applicant for any future damage to water supplies. So there was all of this information that happened at the district commission level. However, the neighbors had no experts. So when it went to court, an environmental court, the neighbors fortunately found a pro bono lawyer who brought in an expert on the water contamination issues, and we found a blasting expert. And so all of this information came in, but regrettably, none of the information from below came in. So there was never any demonstration of a test blast. There was never anything that happened at the court level where the judge actually compared a blast to his daughter slamming the screen door, where the neighbors had testified that a blast went off and their mobile home park came apart, or their mobile home came apart. So I really like the idea of not throwing out the record down below, but I am very concerned about limiting what can be brought in if there is an appeal. And I would suggest that the first step in designing something like this is to rename it. This is not on the record. Kirsten used the word supplement. I think supplementing the record from the district commission is a good idea, but please keep in mind just how effective and successful a district commission process can be without the lawyers, without the experts, with exchange of information that doesn't require discovery. All of these things are something to really hold on to, and don't make district commissions lawyered up. That's going to ruin the process. That's going to turn it into the nightmare of the Public Utility Commission process that is almost impossible to find a lawyer. And so there's this idea that neighbors are a problem. Neighbors are the ones who know all about the communities. Neighbors are the ones who know all about the environment. They're the ones that have the knowledge base. we need to value the input from the community and the people who know the neighborhood the best, and also understand that not all development proposals are good proposals, and that Act 250 doesn't just deal with housing. There are a lot of other types of issues, commercial developments, industrial developments, that Act 250 is the only one that handles in a lot of cases. So that's my 2 cents on that, but please come up with a different name, as we're not talking about on the record.
Mhm. Thanks, Annette. Appreciate it.
Supplemental record of review or standard of review with supplemental record. I don't know. We'll make Brooke come up with some brilliant new name.
Okay.
Don't
I'll
don't
try.
fail us now, Brooke.
As long as it's not Latin, Brooke, we want just plain English.
No worries. No
Okay. So we have 5 minutes left on this issue. Do you feel that you've covered your bases, Brooke?
I do, but I would like a little clarification. What, if anything, additional in terms of besides me starting to try to craft this? Do you want any other data or information? Either, you know, which are possibly able to be coordinated. I think that's a lot of time waste to figure that out. I don't think that that's that big a deal. I think we have other stats that give us generalized, you know, there are a handful, less than 5 a year at the court for consolidation. But if you want more info on that, or on more information about these housing appeals, we can go back to the other 2 years. It took about, I don't know, about 2 hours to get the ones that I got, maybe 3 hours, something like that.
I wonder if you start drafting, whether you, you know, we look at a draft, whether we feel that we need to do the additional research. Do you see what I mean? Like maybe
That would be
maybe
good.
there will be clarity about whether we need to get more data. And I thought there was a reference about, somebody made a reference to Jenny and her ability to look at our records, for some more information.
Yeah, so I can use those. She's kept track of our Act 250 cases for the past 2 or 3 years.
Yeah.
And so if we wanted to cross-reference Act 250 with the zoning appeals to see how many of them were common,
Yeah.
and could be consolidated, she has good records on our Act 250 cases.
So maybe let's do that, but not, you know, not getting more details on the court cases for the last several years and reading more. Yeah, let's do that. What do you guys, what do the rest of you think?
I agree. I'm not convinced that I need more data to start to review recommendations on this. And I like Janet's suggestion that if we get to a point where the recommendation doesn't seem to have enough data behind it, we can go out and verify. But I don't need a whole lot more in terms of data analysis from you, Brooke. Mostly just synthesizing recommendations for us to chew on.
And I see Sarah nodding, and I see Kirsten nodded. So yeah. Sound good, Brooke?
Yeah, so let me come back to you with just a draft of sort of the model and the standards. We'll come up with a good name, or maybe we can vote on a couple options. But that's very useful, and we want to focus on deference for factual findings and be free to make our own conclusions. So I'm good. This is very useful. Thank you all.
Okay. Thank you, Brooke. Let's go back to our agenda. Next on the agenda is discussion and possible action on appeals, enforcement, and personnel matters. Might I entertain a motion?
Sure, I'll make the motion.
I'll
It's
wing it.
just a, okay. Go ahead,
The
Brooke,
board
if you
needs
want to.
to. Okay, the board needs to discuss pending appeals and enforcement actions,
Personnel.
not. Okay. Let me start over. The board needs to discuss appeals, enforcement actions and other legal matters with our counsel, the premature public knowledge of which would prejudice the board. Therefore, I would move that we make a finding as such and go into executive session for those matters as well as for personnel matters.
Second.
I'll second. Oh, Alex.
Okay, any further discussion? Okay, hearing none. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Aye.
That is unanimous. So we will enter into executive session. And I expect to come back out within the hour. And then our last item of business would be to adjourn. So we will see you on the other side of this if you choose to hang around. Thank you.
I choose not to hang around, so if it suits your convenience, I guess you can stay here. Kirsten, I do have a quick question for you. Earlier in the meeting, I thought you said Billy Costa was online,
Yeah, he was.
Yeah, he
and I
was.
never saw him on the screen.
Oh, his name
Brooke, will you talk so we know that your sound is working? You're muted.
We're here. If you can
Okay.
hear us.
Yep. Okay, we are back from executive session and have no news to report out of that executive session. So do I have a motion? Sarah,
I motion to adjourn.
thank you.
I'll second.
Thank you, Kirsten. All those in favor of adjourning, please say aye. Aye.
Aye.
Aye.
Aye.
That is all 5 of us. Thank you, everybody. See you next time.
Thank you.
Bye.